Good evening and welcome to this webinar which ELI has put on as part of the series on the Conference of the Future of Europe. As you may know, the European Law Institute, or as I shall refer to it throughout as ELI, is an organization that is about 10.25 years old. It was founded to try and bring together academic practitioners, practitioners who work in the courts, and those who practice and sit as judges, to try and ensure the uniform and speedy development of European law. I do not think when it was founded, those that founded it can have had any idea of the extraordinary rapidity of change that the legal systems of every country in the world are now facing, particularly as regards the effect of the digital fourth industrial revolution, or as regards the very serious issues that have arisen in relation to the environment and to climate change, amongst other things. And so it is a body that has made already, in the short time it has been in existence, a significant contribution to the development of European law. Now, as ELI has this very pan-European view, it thought it ought to participate in the Conference on the Future of Europe. And the conference is an opportunity for citizens to discuss and contribute to the debate about the future of Europe. And the objective is to lead people towards the drafting of collectively agreed proposals. Now you might immediately ask the question, what has business and human rights got to do with the future of Europe? It has a great deal. Every time you buy something, you look often and see where it's made. And so much of it these days is made outside Europe. And sometimes in conditions where we would be horrified to see what was happening, the standards of safety, the use of child labor, and the like. And of course, as nations very responsible and thinking about how it is what we can do to improve the position of people who are involved in such or subjected to such difficult practices, it's important that we do what we can to remedy them and also to raise their standards of living and the standards of safety and work they have. And therefore, this is very much what I would look on as a very important part of defining Europe as a series of nations which has the welfare of others in the world close to their hearts. Now, the way in which this is going to work is as follows. We will have a short introduction by the two speakers, and I'll introduce those in a moment. And then we have prepared about 5 questions. And when I get to the first one, I'll introduce that to you. But let us first turn to the speakers. Both are very closely associated with ELI. And first of all, we're going to hear from Diana Wallace. She has an enormous experience of Europe. She's worked across much of Europe and was a member of the European Parliament from 1999 to 2012, primarily at first as a member of the Legal Affairs Committee, doing legislative work focusing on European private international law, contract law, ADR and mediation, collective redress, e-justice, and the report on the role of the national judge in European law. In 2007, she was elected to serve as Vice President of the European Parliament with specific responsibility for transparency and access to documents. Since leaving the Parliament in 2012, she's been extraordinarily active in the European legal field, and it was the great honor of ELI to have her as a president for 2 years, and she did an enormous amount to build upon the work that had been done in founding it and has been instrumental in bringing ELI to the position it now occupies. She's a member of the Law Society's, UK Law Society's EU Committee, trustee of the European Law Academy. I could go on and on to show what an expertise she has, but there is no need for me to say any more. She's active, present in a field particularly relevant to this evening's debate, and that is in relation to methods of dispute resolution, particularly mediation. And so I'm going to ask her first to outline her views of this topic, and then we'll turn to Robert Bray, who also has a very distinguished record in this field, and we'll come to him in a moment. Diana.
Well, thank you so much for that introduction. I confess we perhaps thought that Robert might go first, but I'm happy to go first if Robert is happy for me to go first.
Certainly, of course.
Right. All right then, well, in that case, let me say a little about how this topic came onto Ellie's desk. And that takes us back to 2017, when the European Fundamental Rights Agency, which of course is tasked with looking at fundamental rights for the Union, produced an opinion which looked at the whole area of access to remedy in connection with abuses of human rights by corporates. And when the Rights Agency produced this report, somebody from there, it's called Jonas Grimhagen, got in touch with me and said, how about a joint project? And it seemed to me an excellent idea to use their expertise and to use Ellie's network of experts, be they judges, practicing lawyers, academics, whatever. And so our work as a team on this subject came into being. And I suppose the basic problem is that the UN guidelines on this subject have always foreseen that it was down to states in the European context, member states, to provide access to remedy. But frankly, over the years, this hasn't been going particularly well. States have been asked to produce action plans, but it's still the case that victims face many legal and practical obstacles if they try to obtain remedy for human rights abuses. And this seems so bizarre when you think about it. When you think that the European Union now has its own Charter of Fundamental Rights, it prizes itself on the centrality of rights to its sort of legal construct, to its values, to how the internal market runs, how its institutions conduct themselves. Fundamental rights form part of the external policy of the Union, part of its commercial policy. So why is it then that within the Union's legal framework, victims of human rights abuses have such trouble accessing remedy? And when you think, in addition, that as EU citizens, as EU consumers within that internal market, we expect high standards. If we buy goods or use services within the internal market and something goes wrong, we expect, and we normally can, get access to a remedy. And increasingly, as consumers and citizens, we have seen that the EU ensures within the internal market that there are high environmental standards and high animal welfare standards. So what about human rights standards? And it seems that, civil society, if asked to think about this, and we'll be interested to know what you think about it, when you're asked to think about it, people say, it's a no-brainer. Of course, we want to ensure that people that suffer abuse of human rights should have access to a remedy. So what's stopping this? Well, we looked at some of the issues, and Robert is really the expert on private international law. But one of the issues is that it becomes so difficult to decide in which court these issues will be dealt with, in which state's court, which state law you apply to it. And this is all very interesting for lawyers, but not so interesting for the victim. In addition, there are a whole lot of issues of procedural law. One of the best vehicles, it's often thought, for dealing with these sorts of claims might be so-called group actions. But every state is very jealous of its own procedural law and perhaps not so keen on the EU having too much say or too much harmonization of this area of law. Although I'd like to say that ELI has also done a lot of work in that area, trying to show that going forward, we need a much more flexible approach, giving greater party autonomy to parties and judges to solve legal cases. And that might help in this instance as well. But there are lots of legal and practical problems. So one of the other possibilities we looked at was the use of ADR. The European Union has been very successful at using forms of ADR, so mediation, conciliation, in the consumer field. So would it be useful here? Well, yes, possibly, as a preventative measure, but you should at least do the same as has been done with the consumer field, that ADR bodies would need to be regulated. Otherwise, there's a fear that they could be captured in a sense by corporates. Remember, ADRs depend in the main on consent of the parties. Whereas what you need when there has been a human rights abuse, you have an imbalance of power between the parties, and you almost certainly need the coercive powers of the state to ensure that remedy is delivered. And the same goes for ideas about due diligence. Due diligence sounds very good. You get companies to, tick boxes that they've done the right things to ensure that human rights abuses don't occur down their supply chain. But that too needs enforcement. A, it needs to be mandatory, and B, there need to be clear standards of a duty of care that the company is subject to. But all that sounds quite complicated. And we also came up with an idea that others have thought of before, and we tried to put more flesh on to break through a lot of these difficulties and do something specific at an EU level. And what we thought was, why couldn't you have a European level ombudsman? So a corporate responsibility ombudsman, and give that post really sufficient powers to investigate, to fine, to compensate. And then you cut through many of these complicated issues that I've outlined. One of the models we looked at was the Danish consumer ombudsman. But what you really need is something very much designed for this area. But we think it could be a possibility. So just to conclude, the EU, as we are all very clear, is no longer just a very complicated, excellent market. As we look to the future, as we look now at the way Europe might develop, it's more and more based on values. And key to those values must surely be the protection of fundamental and human rights. And if we can't deliver remedy there, then something is not right. Thank you.
Thank you, Diana, for that excellent introduction to the overall project. And I'm going to turn to Robert Bray. Before his retirement, and for about 20 years, he worked for the legal service of the European Parliament and in the Secretariat, particularly in the Secretariat of the Committee for Legal Affairs and the Internal Markets. And he became the head of unit and played a very critical role in the development of much of the work that was done. Before then, he was a lawyer and a linguist in private industry for the Court of Justice of the European Communities and for the European Economic and Social Committee and the Bank for International Settlements. He has a great expertise in private international law. And now that he is a member of the Council of ELI, he has been extremely active, not only on this project, but in other projects that look at the umbrella under which some of these projects come, particularly those relating to corporate criminal liability, and a project that ELI is embarking on in relation to ecocide. I look forward very much to his introduction to this subject before we turn to the main part of the proceedings.
Thank you, John, and thank you, Diana. I'm going to start a little bit off topic because this is about the conference about the future of Europe, and Europe always maintains, and it should be, a Europe of values. Having said that, back in 1960, when I was at school, at grammar school, my mother went to Marks and Spencer's to buy my clothes for the winter school in winter term in September. And 90% of the products were British made. The prices were high, there were factory acts, there were factories inspectors, and there were trade unions. All that work is now gone to the third world, for better or for worse. But at the same time, we find that all those things are diminishing in our own countries. The factory inspectorate is no longer what it was. The trade unions are no longer what they were. And legal aid is no longer what it was. So if you read the Financial Times, there have been some interesting articles on very low labour standards in the city of Leicester in Europe. And I think that in defending the fundamental rights and human rights of people outside the European Union, we are also defending our own. Back on topic, so what we are talking about in my part of this, this report is whether and to what extent citizens of third countries should have access to the courts in Europe against multinationals based in Europe for violations of human rights and environmental damage committed by their subsidiaries or business partners abroad. What this may entail is changes in the law. But before we think about changes in the law, we have to consider whether change is necessary, desirable, or even feasible, and also whether there may not be unintended consequences. What gives rise to this are these terrible cases which we've seen in the past. In 1984, there was the Union Carbide Bhopal disaster, where an action brought in the US was not entertained in the end on the ground of forum non-convenience. The collapse in 2013 of the Rana Plaza building in Bangladesh, which left over 1,000 dead and 2,500 injured. A retailer was sued in Canada, but the courts held that liability was indeterminate and it wasn't fair to hold it responsible. And lastly, those are the facts underlying the Ogoni people's litigation in Nigeria in various jurisdictions around the world. Today, as Diana mentioned, the EU has adopted a bureaucratic approach by requiring multinational companies to conduct social audits in compliance with the non-financial reporting directive. And this is paralleled by the UN guiding principles on business and human rights, the OECD guidelines, and so on. Apart from the good, these guidelines undoubtedly do, they have most probably influenced the growing tendency of judges in many countries to infer a duty of care for multinationals, and they could form the basis of an EU instrument of the sort proposed recently by the European Parliament. However, whereas there are good multinational companies which do their best to adhere and take seriously these duties of due diligence, some multinationals deliberately take advantage of the shortcomings of the legal systems in certain third countries and continue to pursue profit at the expense of human rights and environmental protection in the territory of those states. Past experience shows that these shortcomings are often exacerbated by weak administrations and corruptions. It is thus unlikely that reporting obligations on their own will constitute an adequately dissuasive tool. The victims of human rights or environmental violations in these countries often have little or no access to remedy in the domestic courts. And there is also the consideration that claimants in third countries may prefer to bring proceedings against parent companies where the local entities in the supply chain are undercapitalized and claimant unfriendly. So one question which arises is whether it would be useful to change the EU's rules on private international law and conflicts of law. I will not go into detail, but I will mention Article 16 of the Rome II regulation on overriding mandatory provisions. This could be amended, as the European Parliament suggests, so as to allow a court to apply the higher European standards in lieu of the third country's law. Then there is Article 17 of the Rome II regulation on rules and safety and conduct, which some people say could be applied in order to apply higher standards. And finally, there is the idea of the introduction of a forum of necessity. Having said that, third countries' laws are not necessarily bad. Soviet Russia was notorious for having a magnificent constitution, which was never applied. And we must also beware of parallel proceedings and abuse of process. We mustn't get too enthusiastic and say automatically, always, every single litigant in a third country which has been done wrong should necessarily be entitled to bring proceedings in a European court. There is an English case called Municipio di Mariana, where the judge discusses and rejects the idea of bringing these proceedings in the United Kingdom because of the danger of parallel proceedings and abuse of process. The proceedings were going on quite happily in Brazil, and there was no need to conduct proceedings in Europe. So the old idea of international comity still has some relevance. Some people might even argue that it's presumptuous of us Europeans to lay down the law about some things such as child labor to people in very different circumstances than our own, especially when child labor was only abolished in the UK in 1933. Having said that, it was abolished in Prussia in 1839. Also, is it not possible to argue that judges, especially in the Netherlands, the example I would take was Milieu Defensie against Shell, the recent case, and the recent case in England and Wales in Okapi, and that these judges are doing very well in managing to find a duty of care on the part of parent companies and changing the law. There is also increasing national legislation on the matter. There's the French law on the devoir de vigilance and the German law on die unternehmerische Sorgfaltspflichten in Lieferketten. This raises the question whether we could not and should not perhaps have a EU regulation based on Article 114 of the Treaty on the Functioning of the European Union, which would create a statutory duty of diligence. This could be justified on the same sort of arguments as the Tobacco Advertising Directive. The European Union, the European Commission rather, undertook some time ago to come up with a proposal for a regulation, but we are still waiting. This reflects the difficulty of the process, which any process has to go through before it even gets released to the co-legislators, the European Parliament and the Council. There are consultations, including consultations within the European Commission itself. And the length of time the Commission is taking to produce a proposal reflects the difficulty of the matter. There will also be inevitably an impact assessment. So any ideas will have to be robust and realistic and of real assistance to litigants and the courts. And your ideas, I hope, can make a real contribution to this debate. Thank you.
Well, thank you very much indeed, Robert, for both of you to explaining why this is important for the future of Europe, how important it is that we set values, the difficult questions that sometimes might arise in judging whether we should have a sort of laissez-faire attitude or an attitude really that reflects our values. But the main object of this evening is to look at the remedies and the methods by which we can do something about the problems which have been outlined. Now, the way we're going to do this is as follows. We've posed 5 questions, and they will come in turn, and we will discuss each in turn. But essentially, each of them goes to means by which action can be taken, which will be effective. Now, in addition to those questions, and I'll read them out, and you'll be asked to vote before we start the discussion on each, you are very welcome to raise your own questions and your own ideas. Indeed, it's heartening to see in one of the questions raised so far the suggestion about involving litigation about obligations in relation to a supply chain, and that we will be coming to. So what I would like to do is go to the first question, which will be put up on the screen now. I will explain the open questions I'll come back to encourage you about that in a moment. Now, this first question reads, do you think that proceedings should be able to be brought in national courts in Europe against companies supplying goods or providing services in Europe for breaches of human rights, damage to the environment in countries outside Europe? This is a question, you have 3 answers, yes, no, and you don't know. But this is a particularly important question. To what extent should we in Europe provide the forum or the place of the remedy for what has happened outside Europe? And so I would give you a moment or two to vote, and then we will have the answer and we can start the discussion against the background of whether you all think this is a wonderful idea or all wholly opposed to it. Well, the answer is pretty clear-cut. 83% think the answer is yes. Only 4% think no, and 13% are, I think I don't know. I take that to mean you're undecided. The arguments go both ways. Well, now, what I would like to do while you're thinking of questions to ask, and please put the questions in the Q&A. And if a really good question comes up, I am able to ask those operating the system to try and connect you so you can give the question and tease the answer out live. But let's see how we go. Can I therefore please ask, and this time I'm going to ask Robert what he feels about the reaction of the participants to that.
Yes, I think it was a bit of a tricky question, really, because the answer must be really, it all depends. But in the right circumstances, yes, I think it is correct that litigants in countries or victims of violations of human rights, fundamental rights, or of environmental depredations carried out by European countries through their subsidiaries or through business partners should in general be able to bring proceedings in Europe where they cannot successfully bring proceedings at home. I think that is all where, because it often happens that there is corruption locally or a bad court system or whatever, and European courts are the answer, because we all know they're excellent on the whole.
Yeah, Diana, can I ask you for your views on this, and then we'll go to the first of the questions. You're muted.
I think, like Robert, that has to be the right answer. But subject to this, I would say that there has to be a clear system, in the sense that what we see too often now is so much litigation about the place where a case should rightly or wrongly be litigated, and that is no service to the victims. So it needs to be clear that it should or can come to Europe without too much argument, if that's what you want to achieve, because otherwise you could be in for a lot of litigation about where you litigate, and I don't think that serves the victims well either.
Well, thank you very much for those answers. Now, there are two questions which I think I can run together. And the first is from John Gaffney, which says, why no mention of the potential role of international arbitrations? The Hague rules merit strong consideration. And then Luciano Podroli asks, what sort of proceedings, civil or criminal? And I think it's possible to take those together, because they're all, or they can be done in combination possibly, but they really are alternatives. Diana, being the expert on arbitration, what do you think about this?
Well, I think overall in our project, we were clearly talking about civil issues and civil litigation. So far as the Hague rules on arbitration are concerned, we did look at them as we looked at other forms of ADR. And of course, they absolutely merit strong consideration. But the overwhelming feeling of the team, and I think that sort of is reflected in the answer to this question, is that fine to use these options, but it needs to be against the backdrop of an absolutely clear black letter law framework, so that there is clarity, and that, as I mentioned in the introduction, when you need it, you have the ability to use the coercive powers of the state to get a remedy and to enforce a remedy. Now, we can argue about whether or not arbitration can achieve that. In some circumstances it can, but I think what we wanted to see, and what the team as a whole wanted to see, was a clear black letter law backdrop that offered no or little room for argument.
Now, before you answer, Robert, there are two supplementary questions which build into this. One by Giorgio Sanchiolo is that wondering how the EU would take arbitration, bearing in mind its track record. And Thomas Mayer, who posed the original question, asks, should the proceedings be individual or collective? I think that's a much easier question, but if you'd like to answer those in answering everything together.
Actually, I would like to answer Thomas Mayer's question about the German supply chain law, because I think
no, can we come to that, Robert? That comes, but we'll come to that as a separate question.
Okay, individual or collective, I didn't see that one up there. Yes, well, that is one of the things that we do consider in our report, because the idea of class actions obviously enters into here, and the idea of basing some sort of class action on the EU consumer class action has been discussed in our report. As far as the question of arbitration is concerned, the EU has always steered clear of this. Even Brussels the Commission has tried to introduce rules on arbitration in Brussels I, and the other institutions, the Parliament and the Council, have been determined to keep arbitration well out of it. It's all covered by the New York Convention, and people like to leave arbitration out of the ambit of EU law. But
well, I'm going to stop the discussion on this question now, because having had such a very clear view from those participating in this, and having had your comments, can we move to the second question, which I would ask be put up? And this goes to a very interesting issue which has been touched on, namely, should we really take into account doing something better in the countries? And the question is this: what do you think is the best way to deal with these issues? Formal legal proceedings in Europe or solutions in non-European countries? And there are three possible answers: formal legal proceedings in Europe, solutions in non-European countries, helping improve their justice system, or developing softer means of getting corporations to work together with the local population, or some other method. It'll be very interesting to see, having heard the answers to that, what you think the answers are to this. So we'll have a pause while this question is answered. Well, the answer this is a much more narrowly divided one, and it'll be very interesting to have your comments. 38% take the view that we ought to have formal proceedings in Europe. 49% think solution in non-European countries, improving their justice system or developing other options. And then they're about the same number who aren't quite sure in relation to these alternatives. And I think that it would be good now to go back to the discussion and see what questions have come up in the chat on this. There's a comment by Giorgio Sangiolo to the effect that we would need multiple choice, a smart mix of measures, which I think might be the common sense answer to this. But for the second question, you need both. They're not mutually exclusive. But could I ask you both to comment on the efficacy of actually being able to help resolve these matters in the home country? Can we effectively improve justice systems? Or are we going to find that big business manages to subvert the justice system, or alternatively ensures that the laws passed locally really are ones that deny remedies? Robert, would you like to answer that first?
Well, I think that there is certainly room for the EU to assist and help other countries improve their justice systems, always assuming, of course, that the countries want to be assisted and helped. The EU and George Soros helped the countries in Eastern Europe modernize and update their civil services and their legal systems. I believe, in fact, the British were helping the Russians at one stage in improving their judicial system after the Iron Curtain came down. So that would be quite possible. On the other hand, I think as far as bringing proceedings in Europe is concerned, I think the best way is to create a statutory duty of care on these multinational companies, which gets passed down the supply chain by way of contract, so that you eliminate a lot of the difficulties involved by private international law, because private international law is an expensive game to play. You can waste a lot of time deciding on which court has jurisdiction, which law is applicable, whether there's a triable issue. All these things can go on and on and on and cost vast amounts of money, which is great fun for multinational corporations, but not so much for victims, particularly victims without deep pockets. And I think that a simpler solution would be able to sue the multinational directly for breach of a duty of care. But you'd have to be carefully constructed.
Diana.
Yeah, I mean, I think the idea that people have to litigate far away from their home in European courts and use our courts and our system and our laws can make one feel a bit queasy. It's a sort of almost a legal imperialism. But by the same token, if we are wanting to make sure that the goods we have and the companies that operate in our market operate to European standards, clearly that seems like the best option. And Robert's idea about the supply chain, another way of trying to keep European standards upheld. But that said, we clearly want also to have a system where people can go to their local court and can get the right answer there, and indeed get it properly enforced. Because you must never forget that in a sense, you need the justice delivered where the action has occurred, for many reasons, to make sure that others behave themselves, etc., for its educative effect. And if the judgment happens the other side of the globe, that may not be so helpful. So I have a lot of sympathy with those people that say, you know, it's 6 of one and half a dozen of the other. But, you know, if we're going to see an improvement, maybe we have to rely on our courts and our systems to an extent, but please do something domestically, as it were, otherwise where the action has occurred.
Now, we have one more question on supply chains, which I'll come to in a minute. But Pascal Pichonnet asks this question. He points to a point that Diana's just made and refers to the famous case of Lago Agrio in Ecuador, where the Supreme Court made an award of $9.5 billion US. But still, 25 years later, it hasn't been enforced. Can you help us as to the problems of enforcement and give us a view as to whether you think that that really is an overwhelming reason why we should allow or should prefer direct measures in Europe? Robert, why don't you come in on this?
Yes, that was a case involving Chevron on an oil field, if I remember rightly. Yes, clearly, you have an advantage in Europe if you have a solvent multinational, and then you have an award against it, which can be enforced in Europe. Bringing proceedings in a third country where the subsidiary in question may not be solvent, they're often not. One of the reasons why litigants or victims want to bring cases in proceedings in Europe is because the subsidiaries or the suppliers down the supply chain are often insolvent or not very solvent, whereas the multinational is usually highly liquid and has resources. So, and in Europe, we can enforce judgments successfully. So yes, that is another reason for bringing proceedings in Europe, I would say.
Well, can we leave that question now, because keeping an eye on the time, and go really to the question that has been already mentioned in the Q&As, and that relates to the problem of supply chain. And the question I'll ask them to put up in a moment: do you think that good corporate behavior can be encouraged by companies insisting on high standards of behavior in their contracts with all those who they deal with, so as to raise standards throughout supply chains? And so it'd be very interesting to have your views as to whether you think this will be effective. Three answers: yes, no, and I'm not sure. It's come and gone. I saw there's a huge majority in the supply in favor of yes, the use of supply chains. A very small number who think the answer is no, but a much smaller proportion this time of people who aren't sure what the right answer is. Well, now, can we go to the can I go to the two questions that I bypassed, because I knew we were coming to this? And before I ask you to comment, the first is a question from Thomas Mayer, who asks: Germany recently enacted the supply chain law, which obliges corporates to secure that during the whole supply chain, to ensure the whole supply chain doesn't harm human rights. Could the German law be a model for Europe? And then a question is also raised by Ioannis Kelsis: how does the supply chain law affect the not so financially established countries of Southeastern Europe? And if you'd like to build in your answers, taking into account those two questions that have so far been posed. And I might ask Thomas Mayer if he wanted to come in and give his own views on why he thinks the German law would be the answer. But let's hear from the two panelists first.
Yes, the German law is a very interesting law, though it's been watered down quite considerably from the original draft. In fact, civil liability doesn't arise directly under this, and the only way of bringing proceedings, as far as I know, is through trade unions and NGOs. On the other hand, I think this is an important development, as I said in my introduction, in that the French have also got a law on due diligence, and other countries, the Italians, have got something similar. And together, this means that there is a disparity between member states of the European Union, which in fact could prompt the European Union to act and adopt a law of its own, a regulation of its own on the basis of Article 114. Obviously, the German law is a straw in the wind, because the European Union will suffer the same pressures as the German legislator in adopting its law. It's a much weaker law than the original draft, if I've understood it correctly.
Diana, do you want to comment? And then if Thomas Mayer is happy to do so, I will ask the Secretariat to put him on live. Yes, Diana.
This is really Robert's topic, but I would echo what he said. You know, we're approaching a bit of a mismatch where different member states do different things, and that's no bad thing, because you begin to see what the possibilities are. But it makes it more difficult to have a coherent regime, which is of course easier for victims to access. We are of course here trying to look on a European level and hope that the European Union will take such action.
Well, I'm going to inquire whether the Secretariat has been able to see if we haven't tried this before, but let's hope it works. We haven't heard back from Thomas Bray yet. Well, let's carry on for the moment. But can I just pose another question in relation to supply chains? Is the difficulty, even if you didn't have the restriction that only certain people could make or have the standing to bring claims, would it be actually very difficult to show how the damage was rendered to people, and how would you manage to calculate that, or would you just have some form of penalty? And I hope Thomas May will be joining us. He's asking how he does, we're being told. But Robert, could you answer could you help with that question? How do you assess the damages?
Yes, I don't know. It's an interesting question. Yeah. No, I've got no idea how it works in this situation.
Because I think my general experience has been of most corporations is that they always say that doing something wrong has a price. Some don't take that view, but a large number of businessmen do. And therefore, the ability to have damages is really quite important. But can I ask the second, have we managed to connect Thomas Mayer? Let's wait a minute. As if we are, yes. Yes, Thomas Mayer, you're on mute, but if you can unmute yourself, you'll be heard by everyone.
So now maybe you can hear me.
And we can see you, and everyone can see you.
Thanks a lot, first of all, for the honor being now here with you on the panel with such wonderful lawyers of the not the European Union anymore, but at least very much connected to the European Union and to the face on it. First of all, I have to discover that I'm biased in that because I'm working in development cooperation and did for 25 years something what was mentioned in one of the first questions, supporting countries in setting up their legal and judicial systems. And nowadays, I'm joining you from Kiev in the Ukraine, and now I'm in the good governance sector as such. And so the law in Germany was initiated by the Ministry for Development Cooperation. And I totally agree, Mr. Bray, it's a straw in the wind. Yeah? And it's I think widely known in Germany that it is only a starting point maybe for an international discussion or European discussion to go for that. But the thing is, and that's simply the reality, the human rights violations in the countries is often not against their understanding of how to treat people. Yeah? So human rights violations are part of their political and economic systems. And so to give the chance for individuals or groups to go in front of courts is maybe something what could be has to be taken under consideration on the question of sovereignty of the states simply. Yeah, that I feel there is no international law that you have to fulfill all human rights. That's a pretty biased view of the international communities, and I fear that China would not agree that the Uyghurs are offended in their human rights even when they sit in jails and producing maybe some textiles. I do not know exactly. So the approach of the German supply law chain is that in cases offenses are known, then there are fines against the companies. And this fine system seems to be a very successful one in the European Union to fight against international corporates when they violate not only human rights, but also, for example, data protection things. I think, was it now Amazon or WhatsApp who had to pay quite a 3-digit million euro fine in that respect. And it's only an attempt, and it was an attempt by the ministry, and by the way was fighted harshly by the German economics in that field. But the idea behind that is to simply cut away the profits gotten by the violation of human rights, and by that taking away the advantage the corporates gain by exploiting humans and offending their human rights. Thanks a lot for the participation. I'm really honored on that end.
Well, can I thank you very much for clarifying one important point, which is what the sanction is, how you hurt companies in their pockets. And secondly, the contribution is important, and I think shows the true value of a European conversation, as this is plainly a remedy where the participants think that really this ought to have much greater, if one can use the English vernacular, it needs much stronger legs, so it can march to help these issues. But thank you very much. And now can I turn to the next question, which is our fourth question, and that, if it can be put up on the screen now, and it's this: do you think it is helpful or sufficient to rely on a system of companies compulsory self-reporting and auditing themselves on such activities? And then there are three answers: yes, no, and I don't know. And let's give you a few minutes. And I take I don't know to mean I'm not sure. Now, this is, I think, an answer that's consistent with where we've come before. 25% think yes, 63% think no, and slightly larger now numbers are slightly agnostic. This would, I think, indicate that, but it's a matter for the panel on, I very much like their comment, that they're not terribly keen on what one would call self-auditing, self-reliance, even if backed by auditors. Diana, what do you think of this? A, the idea itself, and B, the reaction of the audience to this? Well,
I'm glad of the reaction of the audience in the sense that it feels that seems to feel that we need something stronger, which I think is the way that we went in the report, to saying it's all very well having forms of reporting, due diligence, whatever you call them, and even if they're mandatory, they need the backing of the law. And this idea of a clear standard of duty of care that the companies are going to be held accountable to. So on one level, the self-reporting or auditing is a good exercise, but is it an exercise that is in danger of just being a tick box? And because the problem is, if you don't back it up by something with more strength legally, you're often in the position of the victims or the claimants having to try to prove that the corporate hasn't done what it should have done. Whereas if you have a clear mandatory duty plus a standard of care, you reverse that, and the company has got to show that it kept to the standard of care rather than the victim struggling to prove it. So there's a lot more behind this than in the simple question. But I think there is a place for trying to encourage company's good behaviour, but again, it needs backing up.
Before I ask Robert to comment, could I ask Snezana Stepovic if she could actually finish the question, something's gone, or correct what's come up in our box, because it stops halfway through, and I think something's gone wrong with the typing. But Robert, can I ask you to comment?
Yes, I agree with Diana that this exercise is useful for good companies, but can become just a box-ticking exercise. I think the whole question, well, this is a sort of audit. And if you see what's happened to the auditing profession in Europe, how it doesn't really fulfill its function anymore, you can see exactly why this system is defective. You really need a duty of care in the English sense of the word, in the sense of Lord Atkin's duty of care, because one of the misconceptions here, I think, is that when we talk about a duty of care, this translates into German as Sorgfältigkeitspflicht, which is their meaning for due diligence. So it's there is a subtle difference in meaning. Yeah. Due diligence is not a duty of care as such. And I think what we should be doing is converting the due diligence obligation into a duty of care in the English sense, which means that if they violate it, then they are in trouble and they can be sued by the victims of the violation.
Now, there's one question which we didn't pick up on the last round, and there's one more, but I will pick that up a little later. But there's a question from John Gaffney, which asks, and it fits into this quite well, is there scope for a far wider equivalent of the accord signed between global brands and trades unions created in the aftermath of the Rana Plaza building collapse? In other words, can such an essentially private agreement fill in gaps in the EU framework and provide the firm legal basis for remedies and enforcement? And so there is some scope, is there, for some exercise in a private capacity or by private arrangements, but neither of you really feel that the auditing route is enough. Is that a fair summary of your views?
It's certainly a fair summary of my views. I think the point that John Gaffney raises about the Bangladesh Accords, I mean, yes, but you're dealing after the event, which is you know, we here are looking at after the event to obtain remedy. But if there had been a clear, quick access to remedy backed by a legal framework, they might have got there a lot quicker. I mean, I'm a huge fan, as anybody that knows me is aware, of using mediation and arbitration and any of these methods to try to assist in resolving these things. But with this particular topic area, I felt driven back again and again by the strength of arguments that I heard that it's not enough if you haven't got a hard law framework there, and that's the position I have to say that I've come to.
Robert, and then I want to pick up Snezana's full question, which is now type the rest of it, or the rest of it's come through.
I must say I agree with Diana, but I would like to see what Mr. Gaffney, Robert Gaffney, would propose. It might be interesting to look at it. You know, what sort of private instrument? You know, because the Rana Plaza one was an ad hoc thing tailored to that particular disaster and the aftermath of it. But what would he propose by way of sort of private legislation?
Okay, well, look, let's the Secretariat see whether he also wants to come and join on. But while the Secretariat's doing that, can we turn to Susanna's question, which is internal and external audit should be like ISO standards and should be the same. it is important to be internal and external and as well. And I think what she's asking really, why can't we have uniform standards in that way? Robert.
I'm not sure that I understand the question, actually.
I think what you're saying is that if you have auditing standards which are worldwide, then why won't those standards be, A, you get over the problem of Europe saying, well, you must have better standards than you've got, but B, you permit auditors of companies working on a worldwide, internationally recognized standards to be able to comment and report on those. I think that's the question anyway.
But that won't deliver you a remedy, will it?
We are back to the same answer. Good. Well,
yeah, I think so.
There's before we, while the Secretary is finding out if John Gaffney wants to come and join on that question, can I pick up a question that Ilaria Pretelli has asked? The present EU trend seems to consist in bureaucratization of duties, which seems to be detrimental to fundamental rights and values. Compliance seems more important than respect for human rights and blurs liability. Now, that's an easy question. Diana.
No, that goes to exactly what I've just said. You can create all sorts of standards and systems and this, that, and the other, but, breach of a human right is breach of a human right. And what we were concerned with and what we're talking about now is getting people to be able to access justice, to get a remedy when there's been a breach. And it just seems to me that I think Ilaria is right. We're in danger of overcomplicating it, perhaps by trying to be too nice. And this isn't nice, and we've got to be clear. And we've got to have a proper legal system that achieves it.
Robert, did you want to add to that?
Yeah, no, I would agree with it, because where did this due diligence come from? It comes from corporate social responsibility, which was something invented, I believe, by the tobacco industry in order to make itself look respectable. It was a way of doing something, or seeming to be doing something without actually doing anything. It was a way in which they said, we're selling these things which cause cancer, but we don't actually want to sell them at all. It's just because we've got these clients that need them, and we're going to behave in a corporately responsible way in selling death. And from that, we got corporate social responsibility, which the oil companies, of course, embraced. And then it moved on to due diligence. Obviously, they're making progress. Due diligence is better than corporate social responsibility. If we could have enforceable due diligence, that would be better still.
Well, thank you both very much for that answer. And if Mr. Gaffney is around, the Secretary is seeing if they can get hold of him. But now, can I go to the next question? And I haven't forgotten Talia Kruger's question, because it comes in very nicely at the end. And it is our last question. Do you think it would be a good idea to have some form of standalone European corporate responsibility ombudsman with substantial powers to investigate, fine, and order compensation payments against corporations active in Europe? That is to say, also to be able to name, shame, and punish. And there, again, 3 standard answers: yes, no, and I'm not sure. well, again, a fairly high proportion say yes, there should be one of these bodies. A small number say no, and then I don't know. Well, can I turn to Robert and Diana, and questions we look forward to coming, but it would be very helpful to have your views on the reaction to this particular proposal.
Well, personally, I'm delighted because this is an idea that some of us have been trying to get to fly for a long time. And this was the first time that we had the opportunity to sit down and think about it, and now to test it on an audience and to get what I regard as a very positive response. So I think that's, a possible direction that I see that could cut through a lot of the interminable arguments that we've had in Europe about collective redress, about private international law, etc., etc. You just have one institution with strong investigative powers that can get on with it and can really establish some credibility within Europe and some credibility that really makes them.
Dana, we lost the connection with you, but you're back again.
But I'd finished, I think, so yeah.
Robert, your views on this? And have we, I very much encourage some questions on this there's one that's come and no doubt some more in a moment. Yes, Robert.
Yeah, I'm not, I like the idea, but I'm not all that keen on ombudspersons being able to fine people, because once you get into fining, then you get into appeals and you get into more and more court proceedings and litigation. And it, the European Ombudsman works pretty well actually without that ability to do so. The idea of the compensation payments could be quite interesting if the Ombudsman could negotiate some sort of compensation for victims. That might be an idea,
but can we look at the question raised by Rita Giannini, which is the Ombudsman is a good idea, particularly because judges would award damages to the victims, but would not fine directly the company. I mean, one solution would be, well, the Ombudsman determined liability, and then you look to collective actions to get the money out of the company.
That is something that we'd thought about, that you had a form of follow-on action from an ombudsman's decision, which would be one way of dealing with it. I think we were concerned to put the idea out there and see what circulation it might get. There have been a number of national ombudsmen who have dealt with some of these types of action. Some of them are seen as being sort of successful, but of course, again, you get the problem that if you had somebody that could really look across the European horizon, if you take a case like the Volkswagen case, and all right, that's a consumer matter, but if somebody could really sort of get a grip on these huge claims like that, that would be so much more effective than relying on various national courts and schemes to try to get hold of it effectively.
Well, thank you very much. Robert, your comments on that?
Well, yes, I can see it would fit in quite well with the German law, where you've got a system of administrative penalties, and you could have an ombudsman fitting into some sort of system like that. All these are good, useful and interesting ideas that are really worth thinking about. There's also a case of not burdening the courts too much. If you just could deal with this with an ombudsman's office, it would be much less of a burden on the court than, say, fully fledged proceedings involving disputes about jurisdiction and all this sort of thing.
Well, thank you very, very much indeed. Now, we've very conveniently reached the time where, according to our timetable, we should be now asking both of you to express quite briefly the agreed conclusions. I think some are fairly obvious, but I'm not going to try and answer them for you. But in answering them, I would be very grateful if you would take account of the question that Talia Kruger has asked, and it's this. I find Diana's point about domestic delivery of justice interesting, but what is domestic? Where the damage occurred, the human rights abuses took place, or where a multinational company organized its supply chain and made its profits? And I think that question very neatly encapsulated yet another complexity that arises. And that's why I left it to the end, because I thought it would fit in quite well with your overall summations. Now, which of you wishes to go first?
Shall I lead off? I mean, in answer to that question, when I used the word domestic, what I had in mind was obviously the place where the human rights abuse had occurred. In other words, what I was trying to concentrate on is the sort of educative effect of having a legal process and a judgment delivered against somebody in the place where the wrong has occurred, and that being known about, and it hopefully discouraging others in that same place from behaving in a similar fashion, but also giving encouragement to others who might suffer similar abuse from anybody else to be emboldened to take action themselves. So it works a lot of ways round if you can improve the local justice system and the delivery of justice in some of the third countries that we're possibly talking about. So that was what I had in mind. In terms of a summary, I think I take a lot from the fact that most of the questions have gone more or less in the direction that our report has argued. So for a stronger legal framework, but not losing sight that sometimes there are other ways of dealing with this issue, and that those deserve investigation. And it's a shame we haven't been able to hear from John Gaffney, but that we should keep an open mind, but at the same time realise that it is about time that Europe delivered on its values. Thank you.
Robert.
Yes, as far as Talia's point is concerned, I do agree with Ilaria that we already have this situation of nemine ledere in the environment, where you can sue either at the place where the damage occurred or at the place where the originating omissive conduct took place, which gave rise to the damage. So you can have a choice of law there, different connecting factor. And the place where the profit arise is in fact a good connecting factor for these cases. As far as the moral of what to draw from our discussions, I think is that everybody feels that victims in third countries should, in the proper circumstances, be able to bring proceedings in European courts. I think that's come out quite strongly from this, and that people are in favour of solutions like ombudsman, which are interesting and novel solutions. I was very impressed by the strong vote in favour of that, in fact.
Well, I think Diana asked the answer to the question that John Gaffney, he says he's going to think about this and write more fully, but he says this: in sum, while I don't believe a private agreement is a panacea, it might provide some gap filling and provide a sound basis for arbitration with all the flexibility that arbitration offers on some of the issues raised by the speakers. He appreciates his gratitude for the fascinating discussion and for the panel's consideration of his suggestions. And I think it would be very helpful if you had any comment now on his particular answer of it really being a gap filler. Robert or Diana.
Well, it could be a gap filler, and I'd be the first to say that, you know, arbitration does have an extraordinary flexibility and you know, can get round some of the cross-border procedural issues that the EU finds so difficult sometimes to grapple with in legislation. So I can see the plus side, and I was extraordinarily interested by the work that was done in The Hague that John Gaffney referred to. And maybe I should take more time to look at that as well. But I would be really interested to hear more from him after he's heard our discussion tonight.
Robert, is there anything you wanted to add?
I would just say that overall, I think simple solutions are best, and that any EU regulation would be best setting down a duty of care with a precise content, which could be the United Nations guiding principles, all these sort of things, and make companies abide by the duty of care, which would then give a course of action to people when they breached it. And they could extend this down the line using contract. And I think this would be a simple, straightforward situation. I think one of the problems is that people tend to be complicationists. They tend to think about messing around with the rules of private international law, which are, some of which could be slightly improved, but it's not the source of the problem. The problem is to try and find a simple, straightforward solution to a complex problem, not to add more complexity.
Well, thank you very, very much for those answers. Now, I think we've reached the time where I ought to do two things. I ought to answer the question I posed at the start. What has this subject got to do with the future of Europe? And I think this discussion has shown two important factors. One, Europe has values. And I do think that sometimes we forget that fundamental values, such as the respect for those who provide us with goods or provide us with services, is a part of our makeup and a makeup of the civilized societies in which we live, and maybe distinguish us from other societies. And so that's number one. We value the rights of others in other countries and want to see them protected. And I think the second message is that there seems to be little faith in corporations and much faith in the state. It's been very interesting to see that although, for example, auditors might be thought to be able to provide some sort of assistance, or what John Gaffney raised, some filling in of duties, what I think the overwhelming participation has shown is that this is something that requires state action through the various modalities that have been discussed. And thirdly, I think that it also shows a fundamental human respect for the views of others. There is a concern that we simply don't impose our values without taking into account the views of others. But we must not allow ourselves to be soft-soaped into accepting corporate assurances that all will be well. So I think this has made, if I may say so, a very valuable contribution to the debate on the future of Europe, though it might not be quite in the sense that those who drafted the this program actually had in mind, but it's shown something much deeper and more valuable. But secondly, I think what I would like to do is to say an enormous thank you to the two panelists who've answered with great aplomb. They've explained their quite complicated subject, obviously did it so well because the answers to the questions were so clear. They've answered all your questions. And thirdly, I think I must say thank you to the audience. You've been brilliant. You've asked a lot of questions, some of them quite difficult. You've come up with ideas which need to be thought about and incorporated in our report. And finally, might I add an additional thanks to Katja, who has done so much to ensure that this has worked so well. I think I can say this. I think I took a bit of a gamble when getting someone to participate, but actually Katja did it brilliantly. And if we are to have a conversation, we must actually use modern technology to enable those to participate, because we actually do need to hear the views of those directly involved. And so I was particularly grateful that we got one live and one answer in writing. So thank you all very much. We will, I'm sure, be able to write a good report for the conference on the basis of all the work everyone has done but me. Thank you all very, very much indeed. Thank you.
Thank you, John. Thank you.